morning, everyone. My name is Dan Beardslee. I'm the hearing examiner for Okanogan County. I've been appointed by the county commissioners to hear and make decisions on certain types of land use issues. On most, today we have an administrative appeal, a shoreline drain, and something to consider. On the first two, on the appeal, my decision is final and binding, and the long plat is also, my decision is final and binding. The shoreline variance has another process to go through, because DOE has to approve that if it's approved here. But as far as the county is concerned, my decision is final and binding, subject to the appeal provisions of the county code. That said, it's important to understand that this is an open record public hearing, and it is the basis for any appeals that occur down the road. The appeal procedure will only consider the record developed prior to this hearing and at this hearing. Once the record is closed, no more information can be entered into the record. It's important to understand. In most cases, unless there's a reason to continue the record, leave the record open for further information and that sort of thing. All testimony will be taken under oath. And these hearings are fairly informal. It's not a court proceeding, so there's the rules are fairly lax, but just use common courtesy. When it's your turn to speak, please come up and sit at the table here and speak into the microphone, because everything is recorded, and that's also part of the record. It's important that we have a complete record. We are on the agenda today. I see some familiar faces in the audience, and of course I'm acquainted with staff. So if anybody has an objection to me having holding a hearing on any of these matters, now is your chance to complain about that. So, hearing none, we'll move to the first item on the agenda, which is designated as the Miller Appeal. Mr. Houston and anyone else? Angie, all three of the staff, you swear or affirm under penalty of perjury that the testimony you give today will be the truth?
I do.
Okay. Go ahead.
Thank you, Mr. Beardslee. For your record, I'm Perry Houston, Director of Planning and Community Development for Okanogan County. As such, I am ex officio the administrator of the code. So what you have before you today is an appeal of an administrative decision in the form of a stop work order regarding work that was done on the parcel cited in the staff report that I provided to you electronically yesterday. I have a hard copy if you want that as well.
Okay. Thank you. The record show that Mr. Houston submitted the the staff report on this administrative appeal.
The decision that's under appeal was fairly straightforward. On May 23rd, we received email complaint with photographs of work being done on the parcel in question. It was thought to be in violation of the Shoreline Master Program. My review from curbside, if you will, and review of the photographs, led me to conclude that likely there was a violation. A letter was mailed on May 30th to Jim Waddell, who's the NRC listed on the assessor's website, but as well to Mr. Miller, who I believe is present today to appear before you, who has identified himself as the agent. We tried to to sort through the ownership interest in the property is sufficient to determine that Mr. Miller in fact had ownership, or appears at any rate to have ownership interest, as well as being the identified agent. Mr. Miller contacted me in short order after the notice was mailed, ordering him to stop work on the property, indicated that he wished to appeal the decision. I did receive a written appeal on June 19th. I consider Mr. Miller outstanding to bring the appeal, and that the appeal was timely received. So, with those issues behind us, going to the issues identified in the appeal, it lists a number of things that Mr. Miller's search has been done. I have absolutely no reason to believe none of these are incorrect or haven't been accomplished. The issue before you is they did the work prior to applying for any of the necessary permits. Many of the things you list would be documents in support of a permit application. But back to the point of the beginning, we never received a permit application. Now, when I looked at the parcel, it rang a bell that Mr. Miller had been in to talk about a potential subdivision on the property. That's not before you today, but it did lead me to remember that in that discussion, my staff, and you have a statement in the folder from Angie Hubbard, one or two, outlining the topics that were discussed on that day with Mr. Miller, which was several weeks prior to any of this work being done. I submit that simply to establish that in fact there was at least some understanding of the necessary permitting requirements before any work could be done on that parcel. Now we have two issues in front of you, both turning on the linchpin and the lack of permits, and that's the gazebo that was constructed. Our understanding replaced one that was lost during the fire back in 2014, may well be the case, but there's still the need for a building permit to put that in place. We did not receive, or couldn't find an application for a building permit for that structure. The rest is the work, the clearing and grading, I would characterize it as, on the road and on that one bank upward towards the upper part of the property toward Danzl Road. All of which would require a permit review. The use of the road, this was explained, the use of the road as an existing roadway would be allowed, but any resurfacing or improvement of the road would be required to submit a permit to accomplish, as well as any of the vegetation removal and clearing within the vegetation conservation area, and then that distance rearward of that to the shoreline jurisdiction, which is 200 feet. Now this is all new, shoreline requirements adopted last year in July, I believe it was. We have included the relevant code sections in the materials in your packet. So, moral to the story, I need a permit application. Some of the work may well have been allowable, but that will be determined based upon the review of the submitted permit application, which we do not have. So what I'm asking is that the appeal be denied and that the appellant be instructed to submit the permit application. At this point, it's really not a matter of simply not moving forward with the work has been accomplished. So we need still the permit application to review what has been done to see if any of it or all of it was lawful. In the event some of it was not, then there would...
Always. So I noticed in your stop work order, you instructed Mr. Miller to contact the Corps, WDFW. Do they actually have jurisdiction to go over in high water?
Well, good question. The process that we have, we employ now, and this is, in my humble opinion, transition from what was once upon a time the JARPA process, where that form was filled out, the county served as the clearinghouse, it was disseminated to all of the agencies, Corps of Engineers, amongst them, Fish and Wildlife, DNR in some cases, Department of Ecology, would determine if they had permitting requirements. That has gone by the wayside, and now in all cases, they want the landowner, the developer, the applicant, to contact them directly to determine if in fact they have any permitting requirements. Now, Fish and Wildlife, and I will confess I don't absolutely understand the nature of the legislation adopted last session in terms of how or why that may have expanded Fish and Wildlife's permit requirements in terms of the hydraulic permit. Once upon a time, I would suggest no, they may disagree. Department of Ecology in terms of stormwater, anything in that vegetation conservation area and rearward of that, they do periodically claim jurisdiction. Corps of Engineers, as you know, occasionally they assert jurisdiction on what they argue are navigable waters or waters adjacent to it. We haven't had a recent history where they have claimed jurisdiction, but in keeping with now the policy decision that we have worked out with the other agencies, we always instruct the landowners to contact those agencies to find out.
So if they submit a shoreline substantial development permit application, you would also, that's subject to SEPA, right?
It would be, yes.
Subject to SEPA, so you would notify those agencies anyway, right?
We would, that's correct.
So they would respond. So in the absence of a shoreline permit application, you're simply asking them to contact themselves in advance of presumably submitting a shoreline substantial development permit, correct?
Yes, and then of course the objective in that is if they'll decline jurisdiction, then they'll have to deal with our permitting requirements. If in fact they want something that I wouldn't necessarily ask for, there's some opportunity for them to assemble that information all at the same time.
I understand the subdivision application was never submitted.
Yeah, we do not have a subdivision application.
So as to the gazebo, understanding that it's in the shoreline jurisdiction, correct? It's within 200 feet of ordinary high water.
Correct.
All other things being equal, and there was nothing going on besides the gazebo, does that, any structure require a building permit, or is that, there's some exceptions to what requires a building permit, right?
There are, we have two jurisdictions at work here. One, Okanogan County Building Code, and whether or not the gazebo requires one, I believe the initial response from building was yes. But we also have the shoreline master program requirements. For a structure located in that area would require a development permit.
And there's a dollar threshold on that, right?
Let me ask my experts.
For substantial, for the record, Shar Shoemaker, Okanogan County Planning. For a substantial development permit, there is an exemption for structures or developments under $7,047, in which case they need a shoreline exemption, which is still a permit, but it's an exemption from needing a shoreline substantial development permit.
All right, so I'm not exactly sure what's being appealed here, whether it's the need to have a permit or the stop work order. I mean, I don't have the authority to do anything about stop work order, I don't think, do I?
Well, you said as the appellate body on an administrative level to my decisions, if you believe the stop work order was issued in error, then arguably you could overturn that, subject of course to appeal to Superior Court. The appeal issues, as I understand it, is a request for relief from the stop work order because the appellant wants to move ahead with the restoration. The problem with that is, of course, the restoration would require the same permit applications. So all points go back, all paths lead to the point of beginning. We need an application packet before any work can be conducted on the property, and now, because work has been, before we can determine if that work was lawful, or if in fact there's some restoration that needs to be conducted.
Okay, and the shoreline substantial development permit is administrative?
I believe so, yes.
All right, well, that'll keep me entertained for a while. Is the applicant here and prepared to testify? Mark? Identify yourself for the record, Mark.
Excuse me, I'm Mark C. Miller. I'm the one that requested the hearing.
Do you swear or affirm under penalty of perjury that testimony you give today will be the truth?
Yes. Yes.
Thank you. Go ahead and tell me what you have to tell me. I have your request from, for the appeal, so
Thank you.
tell me what you have to say.
So, I appreciate the chance to talk with you, and I want to first substantiate that I believe that their statements are true, and that where we may have some disagreements, I would apologize for that in advance. I did meet, I'm going to address some of the things that were just said, because my letter kind of speaks for itself, and I just have a couple questions, and then if I may, I'm hoping to introduce a consultant that has some questions that I'd like clarification on, and I'll be done, I hope. I did contact and had personnel from the DNR come down, and I discussed the removal or the hazard tree situation, and asked if they needed any permits from me, and they said no, and I met with I could specify the names, but I met with the Washington Department of Fish and Wildlife, told them what I was thinking of doing, and they said that what I was thinking of doing was not something that would, what I was thinking of doing would require some permits. So I thought I'd just go ahead and use the existing road. I wasn't going to establish a trail or go ahead with some other kind of a route. So I also contacted the Army Corps of Engineers, and on all three of those occasions, no one indicated that I need a permit to do what I was hoping to accomplish. I would agree with Angie and Shar, of course, about questions of subdivision, but that's not contemplated today, and it's not before us today. And so the structure that's called a gazebo, I actually would like to differ. That's probably the area I would differ with the most. I consider that to be an attractive looking shed, frankly. It beats the daylights out of the stuff that's lying refuse along the county road on the way in. That is within the shoreline environment, and I don't see anybody filing complaints about those structures. I brought photos of them, of those, I don't know if you call them improvements, they're just derelict hulks lying along the road. This shed was built prior to the fire, and in fact, it was reconstructed with wood that came from that site. I milled it myself. I reused the same gussets, steel plates, whatnot that went through the fire, so that didn't have a larger carbon footprint and more expense, whatnot. So I consider that to be a shed. And the appeal was really to clarify whether I could continue with the water distribution plan that I had in mind to try to help with the habitat restoration, and that's the truth. I'm hopeful that perhaps today I could get a decision about that subject, or at least a clarification. We really haven't done anything. We haven't done a thing since I got the letter, but I really want to continue to move forward. We hydro-seeded areas and I hope to irrigate those areas, and I was hoping also to plant some vegetation that was part of what the Washington Department of Fish and Wildlife personnel suggested. Some new stems for, reprod of that property. So I'd like to ask about that water distribution question, and I'd like to ask if I could have perhaps an appeal or relief or deletion of the fourth requirement that Perry outlined there's 4 bullet points that are indicated that I need to follow. The fourth one's somewhat redundant, I believe. It's similar to the third one above. So I want to agree with Perry's conclusions, other than I'd like to ask you if I could have that fourth one deleted, and if I could have permission or clarification as to whether I can do the water distribution system. And then I'd like to ask if I could have permission, I'd ask my consultant to come forward. I hired him long before this letter was ever sent to me, because I'm sincere about wanting to improve that property. So, may I do that, and I'll
Well,
excuse
let me ask you a
myself?
couple questions first.
Okay, yeah.
So, is it your contention that a shoreline substantial development permit is not required?
Well, to maintain that road, I didn't think it was. And I to my knowledge, I had the ordinary high water mark delineated and realized that we weren't going to be doing any work either in the water or below the ordinary high water mark. And I would contend that that was just road maintenance. The road was impassable. I couldn't even drive my Subaru in there. And then I went down there the other day to take a picture, and a tree fell across the road again. Lucky no one was there. There might have been killed, and there's a lot of people that go there with or without my permission. But it was a mess after the Carlton complex. I lost a home that day. You did. Jim Weddle did. And we're trying to clean it up.
So, under, I have to enforce the codes that are in place, including the Shoreline Master Program. So under what part of the Shoreline Master Program are you arguing that a shoreline substantial development permit is not required? Is there some specific section, some exemption that you're aware of?
Well, if you're referring to the road maintenance, I'm unfamiliar. I don't know if that's specifically addressed.
All the activities identified
Well,
in his
and then
letter. So
I would
any
agree.
of those would trigger a shoreline substantial development permit according to the section of code that Mr. Houston included in his report. And of course, the whole shoreline master program applies.
I think that's something I wouldn't debate, and I'd like to submit the permits for at this point. Aside from the fourth requirement and the question about the water distribution, I agree with their conclusions, actually.
Well, I think, and Mr. Houston, I'll engage you a little bit here as well. If you submit the permit, those issues will be worked out during that permit process. Isn't that correct?
Per Houston Director of Planning, that's correct.
Saw the shambles of my irrigation system after the
If you
fire.
address me.
Okay.
The,
The evidence, it's a mess.
do you have some reason to believe that a building permit is not required for the gazebo?
It's my understanding that if that's considered, I mean, I don't use the term gazebo, and frankly, I know this sounds, you guys probably think it's just convenient, but I don't even really know what a gazebo, I haven't even looked up the definition for one. But I
Whatever that
consider it at
structure
least to
is,
be a
whatever
nice,
picture
I
is it?
consider it a shed or a structure, no question, and I would be glad to submit that on a site plan. No question, it existed prior to the destruction of it in the Carlton complex. There were other improvements there. We're not going to try to restore them. As I said, I literally had met with the DNR, the Washington Department of Fish and Wildlife and Army Corps about these very subjects. I didn't know the restoration of that building. I wouldn't debate that they're correct if that's what's needed to restore it. However, I should correct one thing. When I talked with you two, when I had the meeting that Shard wrote the letter to address, the building had already been rebuilt. It was a rhetorical question, what transpires down there? I just wanted to know that we already built it. And then we built it prior to the fire. I mean, it's been built a couple times.
You don't have a particular section of the building code or shoreline master program or other county regulation that would suggest that building permits not required?
I think, yes, actually, if I'm not mistaken, the valuation, I wasn't quite able to hear what Shar said, but I thought the valuation is like $6,195. Got that limitation under the the site, and you need to submit a site plan if it's an attic building.
That's a different issue. That's the threshold for a shoreline substantial development permit. I'm talking about a building permit.
Well, if I'm not mistaken, if you build a shed for agricultural purposes, it's actually existed twice.
So what agricultural purpose does that
Well,
shed serve?
if you spend any time there, like I do, it's nice to have a place that you don't have to haul your stuff back and forth all the time. And it's nice to have lockers, so I would hope to put some firefighting equipment there and leave it. I would, if I hadn't dealt with a Carlton complex the same way we all did in this room, I assume, I might have been able to save that place. But luckily I saved a couple other structures, but it was through a lot of hard work, and it was through a lot of danger to myself and my teammates. But I was successful at saving it. I'd like to think that next time that place starts to burn, I can at least be at that location and not 3 others.
So,
Same day.
all right.
The system, the electricity, it might not have burned quite to the extent that it did, except the power went out, because I was irrigating it. But all that burned, and it's gone. And I just have the bills to, at this point.
Okay. Then did you want to have your consultant?
I would,
testify?
yeah, I really
Bring them up
appreciate
here
it.
and,
And my 2 questions are whether I can continue with the water distribution and the bullet point piece on the requirement. I'd like to ask for an appeal on that again. Anyway, thank you very much, all of you. Oh, I should explain, Mike Leslie's going to come up, consultant that I had hired prior to the letter or any of the work. And I'll let him introduce himself. Thank you.
Dan.
Morning, Dan.
Morning, Mike.
Good to see you.
You want to identify yourself?
My name is Mike. To help him with the permitting system. My experience, I was a resource specialist for the Bureau of Reclamation for 8 years. I've been through SEPA, NEPA, shoreline, restoration, mitigation. So the work that we have done already was we've mapped and stuff. I have a couple of questions, and I'll be quick. I went through the letters, and the biggest question is, as far as the shoreline development permit, who would be a point of contact here in Okanogan County? The list of native plants to do for the restoration, I have a good idea what they are, but I want to make sure that they're one and the same. There's an appendix H. Would Mr. Houston be, I haven't been able to find that appendix. Would you be the one to talk to in helping with my submission?
Mr. Houston?
I suspect we can facilitate that.
Great. Mr. Miller can get the water back on that upper area. He had plans to, I was going to help him with this, establish a pollinator habitat area and a wildlife habitat area on that upper bench where there was existing alfalfa there in itself. And the last in Washington State for drawings and such, would the engineer have to verify delineation on the ground as to where these areas are, or is the engineer needed if they're structural drawings?
Well, that's one of those things that, again, that you work out during the shoreline substantial development permit process. That's not a hearing examination.
Okay, I just wanted to ask these
The
questions.
issue before me is the appeal.
Then I am done. I have the information I need to move forward when the time is right.
Okay, thank you.
Thank you.
Mark, did you have anything else?
Maybe just comments if there's public comment, otherwise no, thank you.
Is there anybody in the public that would like to comment on this proposal, this appeal? Hearing none. Anything from staff? Additional?
Perry Houston, Director of Planning, for the sake of the discussion, I would offer a couple of additional photos and a banner of rebuttal. Agricultural building, I guess, is in the eye of the beholder.
I will also make a site visit, in this case, just to see what's going on up there.
I don't believe we have anything additional to offer, maybe you have the information necessary to render decision.
Okay. Very good. Let the record show that Mr. Houston handed me 2 additional photos that will be part of the record. With that, I will, Mark, did you have something additional?
No, I think I'm fine, thank you.
Okay, very good. Then I will close the official record. My decision will be rendered within 10 working days. Usually it's quicker than that, but that's how much time I'm allotted by the county ordinance. So we will move on to the next item. Which is the continuance of the shoreline variance. And this is a continuation of an already open public hearing. So I'll hear from the staff on that.
For the record, Angie Hubbard, Natural Resource Planner, Okanogan County. This hearing is for a shoreline setback variance to reduce.
A little closer to that.
We can't hear you back here. Please, thank you.
This hearing is for a shoreline setback variance to reduce the required 75-foot setback to 50 feet from the ordinary high water mark to place a single-family residence on a 0.68-acre parcel. The hearing was rescheduled for this date in order for the applicant to submit a plat management and mitigation plan in accordance with 1415-430 B and C, which includes a mitigation analysis to achieve no net loss in accordance with 1415-115B. The applicant has also provided a white paper speaking to the variance criteria outlined in 1415-530. This document has been submitted into the record. The project takes place at 3 North Gold Creek Road, Lot 6, Gold Creek Acres Plat, 1973. The lot is 0.68 acres in an R1 zone, and it is adjacent to Gold Creek, which has a rural shoreline designation requiring a 75-foot setback. The applicant is here to answer any questions. Do you have any questions of staff at this time?
I don't. At this point. Well, I do actually, Mr. Houston, I've had a couple of conversations with him about finding some old stream gauge records. Have you had any success in finding those?
For the record, Grace and Director of Planning, I'll assume I'm still under oath.
You are.
Previous, no, we were unable to do so. My staff sought out a number of sources, a bit like a unicorn, everyone knows they exist, but no one has apparently found one yet. So I do not have that information for you.
Okay. I don't know that it's relevant that Gold Creek is a regulated water in the shoreline master program, and we don't have any data to the contrary, so I don't think it matters anyway. So that was the only question I had. Is the applicant here and prepared to testify? Come on up to the microphone. Identify yourself for the record, please.
Jason Stores.
Jason, do you swear or affirm under penalty of perjury that the testimony you give today will be the truth?
Yes.
Okay, go ahead, tell me what you have to tell me. I have your complete file here and all that stuff, so anything you can use to amplify that and build your case is up to you.
Yeah, just trying to build a primary residence on the said parcel number and lot on Gold Creek. And yeah, I guess if there are 10 parcels that were put in place with the water system initially, I think my parcel would be one of 2 that is not built on at this point. And the size of the lot, just looking to meet the space, I suppose.
Right, so you, as I understand, you put a drain field in before the new shoreline master program was adopted, and it was based on the old shoreline master program setbacks, and your planning was based on that, is that correct?
Exactly.
And the original hearing was continued to allow you to develop a habitat management and mitigation plan.
Right.
And I have that in the record, and are you comfortable with the terms of that habitat and management and mitigation plan and implementing those recommendations?
Yes.
Okay. I don't think I have any other questions for you.
Okay.
Okay. And is there anyone from the public wishes to comment on this? Yes, ma'am.
From here, or shall
You
I?
can please come up to the microphone. I'll call you back, Jason, if I need more information. Identify yourself for the record.
For the record, I'm Laura Super, I'm Program Manager for the Methow Valley Citizens Council.
And Laura, do you swear or affirm under penalty of perjury that the testimony you give today will be the truth?
I do.
Okay, go ahead.
I have a prepared statement that I will read from my device. The Citizens Council supports granting this variance for a couple of reasons. The applicant has demonstrated, as required by law, that because of previous buildings and placement of the septic tank, which were done under the previous SMP, it would be very difficult to build a home outside of the 75-foot setback. The applicant seems in the change of setback requirements by things done before the change was made. We're sympathetic to this situation. Also, the habitat management and mitigation plan appears to be well designed by a qualified professional to enhance the vegetation near the stream bank. If successful, this will accomplish the purpose of the 50-foot riparian buffer and 75-foot structure setback to maintain and enhance aquatic and riparian function. The monitoring and contingency plan is critical. We assume that DOE and the county will work with the applicant to make changes that the annual reports indicate could increase the success of the plan. We request that the agencies make the reports available to members of the public who are trying to get in compliance with DOE requirements. So I'd encourage the applicant to check in with the Conservation District if they have any questions or need technical assistance on working through their habitat management plan.
Anything further from the applicant?
No.
All right. All right, then we'll close this hearing as well. I will have my decision out to the planning department, and we'll forward it to the applicants and other interested parties within 10 working days, usually shorter than that, so. All right, then, we'll move on to the last item on the agenda. This is the Eastlake Shores Long Plat 2019-1. Staff have a report.
Yes, it's for the record, Shar Shoemaker, Senior Planner of Okanogan County. I have one item to add to the record. The affidavit of public posting, public notice that was submitted as required. It came in prior, or post, in the sending your report.
Okay. Let the record show that the affidavit of posting has been submitted and is in compliance with the applicable rules.
Before you today is an application for an 8-lot subdivision. The Eastlake Shores Long Plat will divide approximately 8.44 acres into 8 lots, ranging in size from the Okanogan County SEPA responsible official issued a SEPA determination of non-significance. The appeal period has passed, no appeals were received. That decision stands. Here today is Tim Pecca, the agent, as well as Jake Barker, the applicant, to answer any questions. Does the hearings examiner have any further questions of staff at this?
Everybody's here. Identify yourself, please.
I'm Jake Barker.
Jake, you can raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you give today will be the truth?
I do.
Go ahead, tell me what you have to tell me.
Well, I don't have a tremendous amount to tell you. As far as I know, the audit process is the first one of these that I've been involved with, so we've worked our way through it. And as far as we know, we meet the criteria and like to try to get this thing done.
All right, and there's Did you have a chance to review the county staff report?
It was sent to you.
Yes, so I read through it, I did.
And there are, in that staff report, there are some suggested conditions of approval. Do you have any objection to any of those?
I don't.
All right. Yeah, I don't have any more questions. And on this application? Anything further from staff?
No, sir.
All right, then we're gonna close this hearing as well, and I'll have my decision rendered in 10 working days or less. And then with that, I think that is the end of our hearing for today. We'll adjourn.